Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
It's been about 24 hours since November 3rd, 2011, National Love Your Lawyers Day, and I am still waiting for my cards and my thank yous from all the listeners, from Cal, from Seth.
I told you I sent you a card.
This is Frederick Penny, Radio Law Talk. I'm here with my host, Denise Dirks to my right. I got Chris Rodriguez, and I've got Todd Cuden. Welcome.
Good to be here, Fred.
Yeah, we've got Cal Hunter, our illustrious three-time Emmy Award nominee, but never won producer behind the contract.
Often nominated, never the winner. Always the bridesmaid, never the bride.
And Seth Madden, our call screener. If you want to talk to us today, tweet us at Radio Law Talk or call us at 1-855-LAW-RADIO. We've got some interesting things we're going to talk about today. We're going to talk about Bill O'Reilly, his defamation lawsuit against a former New Jersey politician. Kevin Spacey coming out on a number of issues. Remember, these are all, a lot of stuff is allegations,
yes,
by the way.
All morons!
We are all morons.
Kevin Spacey right there.
That's it. Flint River, tell us how you feel, Cal. Flint River, water contamination, the Legionnaire's disease, and Legionella, those issues. By the way, our law firm has had cases on this, and actually Kevin Elder of our law firm is, I'm going to say, one of the top Legionnaires, in my opinion, lawyers in the West Coast. Food delivery drivers of GrubHub. Chris Rodriguez is probably going to touch on a lot of this. Are they independent contractors? Are they employees? There's some lawsuits going on against GrubHub from some, quote, independent contractors that claim they may be employees. And then we got the Consumer Financial Protection Bureau and banks being sued for class actions, whether or not that's allowed, and some issues and laws that Denise is going to get in more details about. But the most important thing we've discussed is National Love Your Lawyer Day, and I'm a little bit disappointed in not getting any cards. Denise, did you get any cards?
I got an email, Love My Lawyer email from Fine Law.
Oh, so did I. I want our business is what they, yeah, I love you, but, oh, yep, oh, wait a minute. Here, Seth Madden just walked in, and I want you guys to take a picture of this. Who's going to tweet it out? Can one of you guys tweet this out?
I think Denise can. She's got the...
Denise has got it. It says, Dear Lawyer Fred. It's got hearts on it. Happy Love Your Lawyer Day. Nobody likes lawyers. RLT. Phone guy. Whatever. That's Seth.
RLT.
That's Radio Law Talk. Radio Law Talk phone guys. So we've got our first card.
It would have been nicer, Fred, but we're out of crayons back here.
Is that a Hallmark?
It's a Hallmark. Well, no, it starts with an H, but it's not Hallmark. But it's it says a little house. It's got 1, 2, 3, 4, 5, 6, 7, 8, 9 hearts. I think we'll post it on our Facebook later. We'll take a picture and put it on Facebook, but it'll be tweeted out. Denise is tweeting out right now, right?
See, the problem is, Fred, is that he knows you're going to bill him for the paper.
Well, it's
they get the National Love Your Lawyer Day, and then it shows up on the bill as 0.5 hours reviewed correspondence from client.
That's right. That is classic. That's true. That's exactly what I was scared. Oh my gosh. Actually, what you do is you write your lawyer an email about some legal issue that he or she is working on, and then put in Love Your Lawyer Day, little one of those little cards at the beginning or something, and then get mad at him. Hey, you got to cut. This is Love Your Lawyer Day I was talking about. You can't bill me for that.
I mean, the fact that I put a 5-page dissertation about the strengths and weaknesses of my case in the middle of the card is completely irrelevant.
That's exactly right. Now we've got a spin on Love Your Lawyer Day. So those of you out there who have lawyers, go ahead. Todd just brought it up. Just throw it in there in the card, but like 2-3 page card, and say you can't charge me for Love Your Lawyer Day.
Yeah, that reminds me of a joke I heard the other day, lawyer joke. And it's clean, Cal. It's clean.
My finger's on the button.
Okay, so this lawyer dies, and he goes up to.
It's a he, not a she.
Yes, he goes up to the pearly gates and he contests his death. He says, wait a minute, this is completely wrong. There's no way I should have died. I mean, I am 42 years old. I should not be dead right now. And the guy at the gate says, hold on a second. How old did you say you were? He says, yeah, 42. He goes, hold on. And he goes in the back, and there's a lot of rummaging, and he comes back out, and he says, you said you're 42? Yeah. Well, according to the billable hours you've turned in, you're 96.
That's exactly right. I've heard that one. Good one, Todd. Good one, Todd.
Love Your Lawyer Day. You're not supposed to tell jokes about lawyers.
Yeah.
Well, Love Your Lawyer Day was yesterday.
Oh,
So
okay.
it's not today.
But there should be a disclaimer, because you can't. It's actually unethical to love your client too much, right? I mean,
It depends. Some states have changed, though. It depends what state you're in.
Yeah, so
Well, it
your
depends.
client may love you, but you better be darn sure you don't love your client back too much.
If you love your client before they're your client, it's okay. If you love your client after they're your client, it may not be.
And loving your client is conditional upon the services you provide as a lawyer.
It's never okay.
That's where you really get into trouble. So I've heard.
Have you guys walked into our case or no case without even knowing it? You
Oh,
walked
my
into
God.
our
Yeah, well, okay, well, then let's go into that
Yeah.
instead of the Love Your Lawyer Day. Here on Radio Law Talk, not only the great topics we talk about, every hour Cal brings up a case or no case. And those of you who want to participate, you can. You could tweet in your answer. He will throw a case scenario out. It could be real. It could be fake. We don't know. What we have to say is it a real or a fake case? And then we have to state our opinion as to what happened or should have happened, and we'll see what happens with that. But that's case or no case. We'll be coming up in a minute. And we're going to talk about an interesting thing. We have a great listener. Believe it or not, we have listeners from Tonga.
Wow.
Fuafa from Tonga, he said he listens to us and he loves our show, and others listen to us back in Tonga. Apparently, there is a extradition issue of a person who allegedly murdered their spouse in Tonga, got on the boat, and then got caught in American Samoa, was drugged to Hawaii, and they're trying to extradite this person back to Tonga to be tried.
And this person apparently is an American.
Yes, he is.
And the issue really comes down to, in Tonga, there is no, the government does not pay for a lawyer if you're indigent or you need help. So we're going to discuss that issue. It's kind of interesting. And this was a last-minute Friday thing that popped up that we didn't do research on except for just the last minute, and it's exciting. And Todd's going to talk more about that, the criminal guy. Remember, November 11th we're slated to add the stations throughout Nevada. As the Nevada
Excuse
Talk
me.
Network.
Yeah. The criminal defense guy, not the criminal guy.
Oh, criminal
defense guy.
He doesn't do crime.
Okay, so what's the difference, really? No. Teasing, of course.
Nothing.
Nothing. Lawyer, just a joke.
Well, I'm going to go back and say the criminal guy. So there we go. I'm the host. I'm keeping it criminal.
Todd received
Perfect.
several cards from his former clients that had plenty of time out behind bars.
That's exactly right. Well, former clients and former people he's put behind bars, too.
They were something your lawyer, but not necessarily love. So yes.
Lots of pictures from the Love Your Lawyer ones, my understanding is. A lot of men in orange suits.
Yeah. Who knows?
It's raining outside today. It says, whoa, hey, the weather.
We talk.
Go ahead.
We talk about the general area of law, and we're not here to give specific legal advice, but if you call in, we'd like to hear from you. We'd like to try to answer your questions in the best way that we can.
Yep, that's our waiver we didn't get to because we're too busy talking about Love Your Lawyer Day and the law, but also remember, a lot of things we're going to talk about, it's allegations. Just because we discuss it doesn't mean it's actually, this is, a complaint is an allegation. A cross complaint is an allegation. So many things we discuss are allegations. But for those of you who are so excited to hear us, our break is coming up in about 15 seconds. Remember, go run really quick and start writing out your card to Love Your Lawyer Day. You can take a picture of it and tweet it to us. We'll be right back. This is Fred Penny. This is Radio Law Talk.
Tweet us, Radio Law Talk.
Send us a Love Your Lawyer card.
No matter where you're listening, you are listening to Radio Law Talk, and you can stream the show on radiolawtalk.com and listen to back episodes too. Go to the website, radiolawtalk.com. You can listen to the show there, and there's a lot of other good information, too. That's radiolawtalk.com.
All right, Cal, we were talking about case or no case. We're going to discuss, apparently, a case that we're kind of touching on. And for the listeners to understand this very important thing, we have no idea what Cal is going to talk about. He doesn't tip us off at all. So roll it, Cal.
Now it's time to play Case or No Case.
First up, before we begin, I must juxtapose you or depose you. Do all of you solemnly affirm that I have not talked to you about any case or no case today? All of you raise your hand and say, oh, sure, whatever.
Sure, whatever.
Thank you. All right. I take you to the great state of Utah.
Okay.
The great state of Utah, where a lawyer who formerly served as an attorney in California went there and started doing a personal injury and divorce. In the course of doing a divorce case, this lawyer, who had a propensity to enjoy company outside of his marriage, shall we say, looked at the divorcee and said, "You are some fine-looking woman." And she said, "And you are some fine-looking lawyer. How about we have intimate relations?"
Okay.
The lawyer said, "Well, that works for me, but first you must sign a disclaimer saying that I am waived of any and all responsibilities or negative connotations to this particular physical relationship." She signed the disclaimer and later sued, claiming she had been irreparably damaged, not by the physical intimacy, but by the overall relationship with...
Cal can even put his own finger on the button on that one.
I'm telling you what, that's walking the gray line.
I have to make it clear that she had been damaged or harmed, would be a better word.
Yeah.
They're all bad words, doesn't matter.
Yeah.
By this particular lawyer and her relationship with him. And so I ask you, distinguished panel, case or no case? Let's start with Fred Penny. Fred Penny.
I knew
case.
you would. First, I want to see what he looks like, to see whether it's a case or no case. I want to make sure I don't know who he is. By the way, those of you who don't know, we do have I do have partners in other states, and we do have one out of the Salt Lake City area. So I hope it's not anyone I know. But interesting. I'm going to talk about ethical violations. There's many ethical violations here. First of all, I'm going to say that he definitely breached some ethical duties under at least the California ethics statutes, but I'm not quite sure about Utah. Case, yes, I believe that's a case that she brought, and I think that she should have brought it due to the fact that he had her sign a waiver and or a disclaimer. I think he has too much power and influence over her at that point, and due to that, I think whatever harm he caused, which I don't know the facts of that, I'm going to assuming that he eventually dumped her and went back to his wife or did something that caused her emotional harm. I think that is clearly a case, and she would win. What her damages are, I'm not quite sure because I don't have all the facts. So I said yes, and yes, a case, yes, she wins damages, but it depends upon what problems or damages she suffered.
But she signed a waiver saying, "I promise."
Doesn't matter. She can sign all the waivers she wants. That doesn't mean the lawyer has the right to take advantage of her.
All right, Denise Dirks, case or no case?
Well, under these facts, she would have a case. And there would be a presumption against the attorney that he had undue influence or overreached in the disclaimer transaction.
Literally overreached?
Stop. Inappropriate comment. That's so hard. It's like softball when I hit. Stop, you guys. I have smoked.
Rodriguez is sitting over there. Oh no!
I have been like covering my own mouth with my hands.
You guys, we do have insurance, but let's be cautious.
So Denise, you say a case?
I say it's case. It's not just ethical violations, but it also is damages. I think she would have damages for emotional distress, perhaps physical injuries, and the conflict of interest that arises. I think he would have to disgorge his fees, so she'd get damages in that way as well. Don't say anything.
I'm making a motion for the engorgement of fees. I mean disgorgement.
Okay. All right. So I say case, and I say if it went to, on that he would have to pay.
All I gotta say is, I guarantee people will say radio law talk. Oh man, they're just gonna talk about law. It's gonna be boring. This is the funnest, most interesting, exciting radio show in the United States. I don't know why we're not on every radio station in the United States.
We will be. We will be.
Go
And,
ahead.
and so now, Mr. Cunin,
Yes.
in the last 2 minutes, you have 1 minute. Chris has the other, case or no case.
All right. So first, I want to point out that there are two ways that he could face liability. One is with the bar, with the state bar, and then the other is if he was sued for negligence, malpractice. I would point out that in California, and this is the benefit of going third as opposed to first, because I do have the ability to look a couple things up. In California, it says that a member shall not require or demand sexual relations with a client as a condition of any professional representation. So no pay for play. It has to be separate.
Right.
Hey, you said he did that.
They shall not employ coercion, intimidation, or undue influence in entering into the relations with the client, and they shall not continue representation with a client with whom they have had relations if such relations cause the member to perform legal services incompetently.
What about other services?
But I'm bummed.
Well, I'm just, yes, you are an incompetent lover. So I would say that the lawyer has a defense, but there was definitely a case filed, definitely with the bar, and probably, as Denise said, in state court for malpractice.
Chris Rodriguez, your turn.
Yeah, real quick, because I know we don't have a ton of time. I believe, given the timing of what you said, I agree with Todd. There was already the lawyer-client relationship established before the physical relationship occurred.
Before fun began.
It doesn't sound like he was such a bad lover that he physically injured her in any way.
Right.
Given that set of circumstances, I say the case was filed. He probably got himself in hot water with the bar, but I don't believe that the case would have succeeded.
Call us and let us know what you think. 855 Law Radio. Or tweet us at Radio Law.
Yeah, we'll be right back after these messages.
If you know of any law case that might be worthy of an appearance on our Case or No Case segment, send the information to info@radiolawtalk.com. Be sure to put Case or No Case in the subject line, and if we use your submission, you're eligible for a special award.
We do have some of those pens left, right, Fred? Now back to the show, radiolawtalk.com. Here's Fred Penny.
Forget that. I might even send them one of our Radio Law Talk T-shirts.
Nice.
Those are really nice.
Nice.
So I've been tweeting and retweeting and Facebooking the picture of that Seth brought me, my Radio Law Talk Love Your Lawyer card. So Cal, just tell us the answer to our exciting
Let's
case
just
or no case.
remind people that the allegation was made here that a lawyer was representing a woman in a divorce. Then the lawyer, in the midst of all that, they decided that they wanted to have an intimate relationship together. And so he had the woman sign a disclaimer clearing him of any and all damages and harm from this physical relationship because it was consensual and not related to the divorce, that they still hadn't finished yet, et cetera, et cetera. And so the question was, is it no case or is it a real case? And the answer is, it is an actual case.
Okay, so the four of us were right on that. Correct. Okay, the four of us were right on that. Now, did they ever give the status of the case?
Here's the backstory. The case ended up going to the Utah Supreme Court.
The backstory.
Yes, well, once again, Fred, once again, you're killing me here. The case goes to the Utah Supreme Court on two tracks. On the case that she filed against the lawyer, liability, and through the Bar Association.
Yeah, we were right.
So he got
hit
both of those.
the applause. We nailed that. All four of us got that. Fred.
And the amount of damages not disclosed.
Oh, not disclosed.
But apparently some restrictions on the law license for a little while, stuff like that. But but here's my cautionary tale, and the reason I wanted to bring this up because I thought it might merit some brief chat because you have other things to talk about, and that is this: disclaimers are usually not worth the paper that they're written on. Is that not true?
That is exactly true. As a personal injury lawyer, I know that for a fact. People will come to me at times and say, well, I was injured on this ride at this amusement park or whatever, and I signed a disclaimer, or I went and did X and Y and I signed a disclaimer. You cannot, as a business or a person, have someone sign away in a disclaimer from you being negligent. So now, the good thing about the disclaimers is it kind of stops people from bringing like the small little cases. It's something to bring up. It's another feather in your cap, but they're very difficult to hold up in a court of law. Oh, that means, I can, you signed this disclaimer and I accidentally shot you. By the way, there was a case we actually handled where a person was at a shooting range, and the what is it? The shooting master,
the range
master, discharged his firearm while people were over there looking at their targets, and it hit a guy in the hand. But the guy signed a disclaimer, right? Come on. I mean, realistically, just common sense says that doesn't matter, which it didn't, and we won that case. By the way.
Disclaimers are like Roundup; they kill the ordinary weeds, but it doesn't stop normal things. So you can't put up a sign in the parking lot that says, hey, park here at your private property, park here. I mean, even those things where people try to wiggle out of possible responsibility for their actions, you've got to be careful about those.
I think it is, I could be wrong about this, I think it's Civil Code 1668. You cannot, by contract, exculpate yourself from your own willful violation of law or intentional misconduct. So there are certain things that certain weeds you can kill, but you can't get out of intentionally doing things on purpose or
negligence to stuff like that.
Negligence you could. Negligence you could.
Well, here's where it helps out. Don't ride this ride if you have. I rode the Manahorn the other day, and by the way, that thing really throws you around. But it says, be prepared. If you got back, neck, or pregnant, don't ride this ride. So that is an issue. But if they're negligent in the way they set up that ride, and they knew about it, and you go through the negligence thing, breach duty, and then they find you can throw that out.
Or some guy says, I know you're a pregnant lady, but you're my friend. Hop on the ride anyway.
Right. It just depends. So again, what do we always say here in Radio Law Talk? It depends upon the facts, right? So it depends upon the facts. Talking about facts, let's talk about this exciting Mr. Fua Fa from Tonga wanted us to talk about the extradition of Dean J. Fletcher. Now, Dean J. Fletcher is an American citizen.
Yes, he is.
And he's rolling in, hanging down on his boat in Tonga with his wife.
Yes.
And while he's down there, he is allegedly, and again, the allegation is that he beats his wife to death and she dies. And so what does he do? He gets on his boat and sails to American Samoa. And as he sails to American Samoa, he gets picked up and he's drugged to Hawaii. Is that right?
Actually, he there's some interesting stuff here.
Let's go to the
interesting stuff here. So he gets arrested in Tonga
on
allegations that he murdered his wife. And he escapes once. He has to go to the bathroom and then does a foot bail, and they catch him.
That works in Tonga, by the way.
It gets better. Then, after he's caught and put back in jail, they put him in his cell for the night. They go their way, and they come back the next morning. The jail cell's empty. And they go to look for him. They can't find him, so they go to the harbor where the boat was docked, and the boat is gone.
Wait a minute. How did he get out of the jail?
I have no idea, but the boat is gone. They find out where it is. They start a pursuit, but they call it off for officer safety because he's too far away. But they kind of found out where he went. He sailed to American Samoa and then hopped a flight to Honolulu. And they were aware that he was headed to Honolulu, where they were waiting for him because the Tongan government wanted to exercise their rights under the treaty they have with the United States for the extradition of people that are accused of crimes back to Tonga. So he was met at the airport in Honolulu and arrested. This was a little over a year ago, and they went through the extradition process to try to get him back to Tonga.
Okay, stop right there. For the listeners, just do briefly, what does that mean, extradition process? Because obviously there are definitely agreements between countries about extradition.
So the agreement between Tonga and the United States is governed by this act called the... Where did I put it here?
I have it too, somewhere.
Called the Fugitive Offenders Act. And
it was signed in the 1930s and then updated in...
It's updated in 67, then 77, then again in 91. And basically what it says is the extradition process works like this. The United States Attorney General comes in, and they go to the local federal court, the U.S. judge in Hawaii, and they seek what's called a provisional detainment, while they try to prove to the judge that there is a treaty that applies and that the alleged crime that was committed in Tonga is covered by the treaty, and can you hold on to this guy while the State Department works out the extradition with Tonga. That passed, and the judge said, okay, there's enough here. The treaty applies. We will hold him. The matter is then turned over to the attorneys with the State Department to negotiate with Tonga about the release, because extradition is not automatic. There are certain conditions that need to apply. And one of those is that they have to look out for the rights of this person who's an American citizen.
Correct.
And they also, this case here presented an anomaly because there is a provision in the treaty whereby if the punishment for the crime is more severe than the punishment in the United States, then they don't necessarily always have to turn the person back over. And in Tonga, the penalty for murder is mandatory death penalty, or alternatively life in prison, but they're heavy on the death penalty. That is not the case in the United States. In the United States, death penalty is always a possibility. The prosecutor can seek it, but it's not mandatory. Chris?
I believe that the reason they do that in Tonga is because if they don't put you to death, there's like a 94% chance you will escape from your prison cell.
Probably.
So, as we've seen.
As we have seen.
Well, and also in Tonga, they do not allow, for people who are indigent or don't have the money, the government will not pay for your lawyer. You still have to get your own lawyer.
And that's what the State Department had a problem with. They're basically saying, so you want us to send this guy back to Tonga, where if he's convicted, death penalty is mandatory, and you're not going to give him an attorney, and he doesn't speak the language. And that was fundamentally unfair, and they negotiated with Tonga to try to say, well, can you provisionally provide him with an attorney? Tonga would not capitulate. They said, no, this is the way that it is, and so they were unable to reach an agreement. The time had expired, and the judge in Hawaii that had this conditional provision said, all right, your time's up. If you haven't reached an agreement, you got to let him out.
But yeah, they let him out.
And they let him out.
And that's what everybody's upset about in Tonga. I mean, in Hawaii, he's like, you're letting this guy out. Now he's roaming around Hawaii on vacation.
That's
so
right.
We're going to talk more about that when we come back from Radio Law Talk after these messages.
Radio Law Talk. I like that show.
And you'll like it too. Now back to Radio Law Talk with Todd, Chris, Denise, and Fred Penny. Hey, Fred.
Hey, so Chris Rodriguez wants to tweet out a picture of a possible Tongan jail, and it's Gilligan Island. I just don't know that we could do that. I mean, we love our Tongan listeners because we have listeners in Tonga.
During the whole segment, and it just shows my maturity level, but you're talking about a really interesting, mature topic. All I'm thinking about is I know that I remember an episode of Gilligan's Island where they had a jail, which makes no sense because they were on a deserted island, so there would be no need for a jail. So I Google at the break, Gilligan's Island jail cell.
Okay,
a great picture.
Go ahead, tweet it out.
Please tweet it, and then we'll move on to something more.
Because we want to move on, and Rodriguez is over there so upset and so excited about his. It's not a Tongan jail.
No, it's a Hawaiian
It's a
jail.
Hawaiian jail.
Well, it was a Tongan jail that he escaped from.
Well, he
And
was
this is the
still
jail.
in Hawaii.
And this is similar to the
Yes.
picture of the jail he's in Hawaii right now.
Whatever you
Or
want
the
it
one
to
he
be.
just got out
This
of.
is the jail he escaped from in Tonga, I believe. If he wears a red rugby shirt and a white Gilligan's hat, then this may be the actual scene from Tonga.
We used to have.
You know,
this was-
interestingly enough, as I look to my left, I'm noticing a similarity between Gilligan and Chris Rodriguez.
And Fred could be the skipper.
I lost weight, little buddy. That's true.
Professor?
No, I want to be the professor. Are you Ginger or are you Marianne?
Marianne.
Oh, okay. All right. I just
Atta girl.
I'm not sure. What's Cal? Isn't he the guy that dies all the time every
I'm one of the
few
guests that
episodes?
show up on the island and then disappear.
Yeah, that's the
How
one.
can they have guest stars on a show where people are marooned, and they always get off the island, and the poor marooned people never do?
Yeah, I don't get that. either.
Cal is Mr. Howell.
Thurston
Thornton Howell, Thurston Howell III.
I
You please call Lufa my stretch marks.
I have 3 Emmy Awards.
No, just nominations.
Nominations, sorry.
If I had the awards, I would be Thurston Howell III.
That's true.
Yeah.
Hey, I can't hear. My mic's kind of down, Cal. I don't know. What's play with? Okay,
No, you sound fine.
yeah, move on.
Getting back to this, the extradition case. So there are a lot of people that are upset that the Tongans are upset because they have an indictment for murder against this guy, and he's not being returned to Tonga to face prosecution. As Denise pointed out, people in Hawaii are upset because this person is released into Hawaii and he is
potentially
being charged with murder. He's accused of murder in another country, and he is now walking the streets of Hawaii, a free man. And you know, you look at this and you say, could this have been avoided if any party, based upon my understanding, and I cannot emphasize this enough, that we don't have all of the inner workings of what's going on with this case. Obviously, we're not privy to the negotiations between the State Department and the Kingdom of Tonga and everything that went on there, but it would appear from the outside that had there been any sort of compromise, maybe he could have been extradited. I will say that from my understanding of the facts of what occurred in Tonga that led to the death of his wife, if true, this is a terrible crime. And it's not like there are not witnesses. I mean, there were 3 witnesses
And it's
that
an
observed beating,
injustice.
and
They saw her. They saw him beating her.
they saw him beating her.
This is
They-
the witness's statement.
Yes, they found a sheet that he tried to throw into the ocean and sink to the bottom of the harbor that was covered with her blood. It was a bed sheet. It was nowhere near the staircase that he claimed that she fell down, which caused her injuries. The autopsy showed that she had suffered injuries that were not consistent with a fall down the steps, but were consistent.
The old dreaded fall down the steps of the small little schooner that's 3 steps kills people, right?
That's right.
That's
And-
a major fall.
And not to mention the fact that attempted escape and escaping from jail, while understandable maybe, is great evidence for a prosecutor to show consciousness of guilt. And so everything that he's done,
can do that?
yeah, if you escape, that shows consciousness of guilt that you were trying to.
O.J. Simpson.
It's similar to when O.J. Simpson was found, he had passports and money and all that stuff with him, and so there's a case here, but it comes down to the fact that the United States was uncomfortable. Rex Tillerson, the Secretary of State, exercised his discretion, which the treaty allowed him to do. And by the way, Tonga has the same discretion if the U.S. was seeking extradition of somebody that was found in Tonga, because it's a reciprocal treaty agreement. Tillerson and his staff was uncomfortable sending a person back to a nation where the likelihood, if convicted, of the death penalty being imposed was almost automatic, and to send a person back there with no lawyer and not able to speak the language
And no money. Apparently he's
and no
indigent.
money, despite the fact that he owned a yacht.
Well, probably it was what do you mean? Yeah, it was probably a 10-foot schooner. You know?
No, it was bigger. This is something they used to sail the world.
Oh, okay.
Yeah, so it was a bigger boat that they had, but he claimed he had no money, and so they didn't
So why'd they release him, Todd? That was one issue. Why'd they release him?
So what happens
why'd
is,
they release him?
on an extradition case, the court says, okay, we will provisionally detain this person while you guys work it out. But we can't detain him
Forever.
indefinitely.
Right.
So they put about a year, a 365-day marker on it, say you got 365 days to work out the extradition of this person to Tonga. And if you don't do that, then the jurisdiction of the court that detains him expires.
Right.
And the judge in Hawaii had no choice. When the year was up, they had to release him because there was no extradition. All right, we got to cut him loose.
Interesting. This is not just an issue in Tonga, but this is an issue with many of countries that we deal with on a constant basis.
It's even an issue in our local jurisdiction. For example, if somebody is arrested and they are not arraigned within 48 hours and they're in custody, they got to release the person. If they're not arraigned within the statutory time, if a person is not brought to trial within a statutory period of time, if they're in custody, they have to be released. And so, I mean, if you look at it basically, that there's an infringement on somebody's liberty. And if the government doesn't do their job to prosecute by a certain period of time,
or have an agreement,
to do that, then the infringement on the liberty has to cease.
Now, people almost always waive time, though, right? I mean, they waive time as a matter of course in criminal courts in the U.S.
Well, they do. I mean, nobody would ever waive time on the 48-hour, you have to charge me within 48 hours. No, I can't think of any defendant that would say, if the DA didn't come in with a complaint after 48 hours and say, you know what, let me stay in custody while you guys take your time and file a complaint.
Right.
Everybody would demand, I need to be released.
But they usually waive the 45-day for have a trial.
That's right. After a person has been charged, if it's in their best interest to waive time to give their attorney a chance to get up to speed,
which usually happens.
Yes, they will waive time. Now, what commonly happens, and I have represented people where this has happened, is if the DA delays prosecution after a time waiver for a period of time, the person does what's called pulling their time waiver. So from the date the time waiver is pulled,
they got 45 days.
They have 45 days to get there. In the misdemeanor case, 30 days to get it to trial.
Right. So an interesting thing about that is in the courts in California, us who do civil practice, we have to wait behind the criminal cases. The criminal cases always take precedence. So when we have a trial, back during, it's about 5-6 years ago, Yolo County was 2 years out before we could even get a courtroom. And a lot of it has to do with the criminal cases. It all depends upon how the criminal cases are stacking up. And so say our turn comes up. And that's a lot of people out there that don't realize that, I'm going to bring a civil case, and why isn't my lawyer getting my case to trial? Okay, we finally made it to trial. We're 12th on the docket. Oh, you get bumped. And you get bumped because here comes a criminal case.
I'll give you an example. So the county that we broadcast Radio Law Talk from, it's a mid-sized county in California. They prosecute 15,000 cases a year in this county alone.
Wow.
And it's those cases that are taking up the docket that don't allow the civil cases. Now, I do know that in this county, they instituted about 10 years ago what they called the Civil Roundup for a while, which was the first part of April. For the first couple of weeks in April, there was an agreement that no criminal cases would be set unless they were extremely serious, so that they could sort of try to get all of the civil cases that were going out, and they'd open up courtrooms and all sorts of stuff. I was practicing criminal law at the time. I was a deputy DA, so those of you that were doing civil law at the time might be able to say if you were involved in that.
We were, but guess what? We still had to wait. So we're going to come back after the hour. We're just almost out of time. We're going to talk about the Bill O'Reilly defamation case. Kevin Spacey is coming out with a number of things we want to discuss. We're going to discuss Flint River. And then we're going to talk about the food delivery drivers of GrubHub.
And if you're interested, we have a picture of the boat. It's called the Sea Oak. We'll put that online so you can get a little closer to the incident.
Listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated. is a live, copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Hour 2 at Radio Law Talk with Denise Dirks, Todd Cunin, and Chris Rodriguez. I'm Frederick Penny, your host, with Cal Hunter behind the glass and our call screener, the crazy, wild Seth Madden.
Fred.
Yes.
Fred. I was listening during the break.
Hold on, I'm going to eat my candy bar.
Eat your candy bar. Yeah. I was listening during the break, Fred, while you were doing a live commercial announcing our introduction into several markets in Nevada. And I noticed that it said you assemble some of the greatest legal minds.
Greatest and brightest.
Greatest and brightest, but it was just some. Now, we're all here every week.
Right. So I didn't tell you, but as soon as we start on November 11th on the radio, Nevada Radio Talk Network, you're out.
I'm out. Okay. All right. So then it will be all of the great legal minds.
Yeah. So it was the greatest and the brightest, and that's why I had to say that. And then we're going to wait till the third hour, weren't we, Denise, to tell him?
Yeah.
But we decided since now we have to officially let you go.
Todd, you didn't know that I am the preeminent legal scholar on all things Gilligan's Island?
I did not know that. It's the first time Wait, am I getting an outright release, or am I being put on waivers?
Well, here's the best part about it. The best part about it, you could probably sue us as an employee. Or an independent contractor, because that's what happened that Chris Rodriguez is going to talk about with, what is it? That's a GrubHub. What the heck is GrubHub?
It's like the greatest thing ever.
Okay, before we talk about GrubHub, let's talk about a couple other little things. First of all, the disclaimer. Denise, tell us this disclaimer we have to mention every time.
We talk about general areas of the law, and we don't give specific legal advice. If you have a legal problem, talk to an attorney in your locality.
That's exactly right. And let's thank some people. Tell them, Denise, exactly what we do with our research and who we have to thank today.
Yeah, we have a program where we have research students from different law schools, and they provide our research for our topics, and they do it in a very short period of time, and they do a good job, and we give them a $100 scholarship, and they provide us with the research. Oh, and most importantly, they get an autographed Radio Law Talk mug, and always a good gift.
Yeah, that's exactly right. Okay, and
so our student today is Tianyu Zhu, and she is from the law school, Whittier Law School, and she's done a great job for us.
Pull it up. Pull a picture around of her. What is going on with all of our?
Hold on a second. As your lawyer, let's stop now. Thank you, Tian.
I could say that. She's a very attractive lady. There's nothing wrong with it. Is that
you cannot say that unless you don't know that it's welcome.
I'm not. I'm just saying thank you. I mean, I think all of our people that have done this great research are. Rodriguez is shaking his head, saying, "Stop."
We're getting to the Kevin Spacey Bill O'Reilly
They're the
segment
best
later
and
on.
the brightest, and we're very lucky.
That's exactly right. The best and the brightest.
Leave the immaturity to me.
Okay, all right. Please. I'm done. Thank you very much.
I've talked to Kevin Spacey about this. Here's what he said.
You're all morons.
Okay. Thank you, Miss Jew. Thank you, Miss Jew. J.U. Thank you, Miss Jew. You did a great job. We appreciate it. And you are going to receive a mug signed by all of us.
And you can list us on your resume.
That's exactly right. Hey, tell your friends, Miss Jew, about us, and let Whittier Law School listen to us. You know what they should probably do at Whittier Law School? They should probably have a class, a Radio Law Talk class. And at Whittier, you go in there and you listen to the podcast, and you get credit. How many credit hours do you think? Maybe a quarter of a credit, or maybe 4 credits? What do you think?
I don't know, but I think that the class ought to involve a segment where people try to be funnier than see who's the funniest, because then it would be truly a Whittier Law School.
Oh my gosh.
Can we go back and talk about Tianyu Jew, please? I'd prefer that.
I'll tell you what, I'm hungry. I want to know about GrubHub.
Tell us about, what is GrubHub, first of all?
Whittier Law School's in L.A. first. People listening across the country, across Nevada, Utah, wherever they're listening, they need to know that Whittier Law School's in Southern California.
Well, Tonga. We got Tongan listeners.
See, how would they know?
They wouldn't know. You're right.
We did. We used to have
Yeah,
Tongan
that's
listeners.
Until somebody posted a photo of the jail.
That's exactly right. No, you know what? I'm telling you, Full Fall loves us.
I tried to be fair. At the last break, I Googled photos of Tongan jails to get some real photos. That same picture kept coming up.
Oh,
so,
jeez.
anyway, let's talk about StubHub.
GrubHub. Okay, what is GrubHub, first of all?
So GrubHub is people that are too busy, let's say busy,
Like us,
to
all
leave
of
their
us.
house,
Right.
and they want to go eat out, but they don't even want to go pick it up at the restaurant. You can get on GrubHub, you place an order, and they will deliver food from a number of different participating restaurants to your house.
Hey, Seth, can we order something from GrubHub this morning? What do we want? Let's send them over here.
You don't order from GrubHub.
But order something and have GrubHub go pick
I
it up.
believe so. I believe so.
You go right on there, so you don't go to some unnamed restaurant like a bird that's green, like Green Robin, for example, or Green Sparrow, and order there and say deliver via GrubHub. You go to GrubHub and order from the Green Sparrow?
I do believe that's correct. You can order right from GrubHub.
How interesting.
Yeah.
Okay, Seth, order something from GrubHub and deliver it to our studio.
Nice.
Do it. I mean, what is it? Cal, what do you want? Are you hungry for breakfast or for?
Oh, just some light lunch fare.
Why
would
don't you
be
get?
fine.
Why don't you get like something a sandwich from someplace and order it, Seth, from GrubHub, and let's have him come in and let's ask the guy when he comes in, unbeknownst to him or her, are you an employee of GrubHub or are you an independent contractor?
This is the kind of planning that we do here.
Yes.
Seth is looking at you from behind the glass going, are you serious? Do you want me to order
I'm
from
serious. Do it. Let's do
Although
it.
we can't really ask the guy without informing him that he's
we're
going
not
to be on
we're
the
not
air.
gonna ask him.
But
Of
let's
course
ask
not.
him. It'll be
Teasing.
fun.
So anyway, the issue here is a driver has filed a class action lawsuit against GrubHub claiming that he was not compensated pursuant to California's wage and hour laws. So basically, I wasn't paid overtime. There are all these additional items of compensation that I am entitled to. And GrubHub's response is, well, you're not an employee. You are an independent contractor that GrubHub has contracted with to perform a service for us. So you're not an employee. You're an independent contractor. The entire lawsuit revolves around whether or not the drivers that pick up the meal at the restaurant and drive it to the person who's ordered the meal's house, whether they are an employee of GrubHub or not. There is a long opinion about whether or not, what factors are applied by the court to make that determination.
Okay, why is that important? Why do we want to know that? What benefits do you get if you're an employee versus an independent contractor?
So we live in a free country, and businesses are. Let's not get political.
Okay, I'm not. I'm just. Oh, I didn't.
Businesses are entitled to contract with one another.
Right.
And you have a lot of freedom, not perfect freedom, but a lot of freedom in terms of what terms you want to contract on. That goes away when you hire somebody as an employee. Then California's labor laws kick in, and they mandate, minimum wage, how much you are paid when you work over 8 hours in a day.
Your breaks.
Your lunch periods, all of those
payment
things.
of taxes, too. It shifts the burden on them.
Absolutely. There's all kinds of things. And so in these types of lawsuits, businesses, it happens in the newspaper industry. There's all kinds of different industries where this happens. And the key issue is this an independent contractor or is this an employee to whom all these labor laws would apply?
And one thing to answer your question also, Denise, is that answer is from the employer standpoint, freedoms. Then there's the employee standpoint, because we have a lot of instances where an employer would say, well, we don't owe you all this because you're an independent contractor, not an employee, but they treat them like an employee. And so for the listeners out there that might be in a situation like this, they need to understand what their rights are, if they're being treated as an independent contractor when in actuality they are an employee. So, for employers that might face liability from people that are listening that might be in one category when they're really another. That's why this is so important.
We're going to talk more about GrubHub when we come back after this break, and Chris Rodriguez, that is his area of law. GrubHub, employees or independent contractors?
Radio Lotta. I like that show.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penny.
I love that little kid. That was the greatest Radio Law Talk little spoof thing that Cal runs. Now we're talking about this GrubHub, and Seth's still trying to get us some grub here. But Chris, independent contractor versus employee in California. Tell me about what does it take to be an independent contractor? I know generally speaking, like there's little things like you have to have your own business cards. You have to. What are all the statistics?
Yeah. So in this particular case, there was an agreement, a written agreement between the driver and GrubHub that says that the driver is an independent contractor.
Okay.
That does not carry much weight, if any, in California. The court is going to look at the entire relationship, in this case, between the driver and GrubHub. The big overarching consideration is, does GrubHub control the details of the driver's employment? Do they tell them when to show up? Do they tell them what they have to wear? Do they tell them what they can do and what they can't do when they're on duty? That's going to be the key inquiry. There are a number of secondary factors that the court will look at. For example, what type of skill level does the job require? What type of equipment is required to perform this work, and who provides it?
Right. So if you say, I'm an independent contractor, but you have no equipment, and you have to use all the equipment of the, quote, business, then
That's right.
It leans toward you're an employee.
That's right. The length of time that you're required to perform the services, whether or not the work that is being done is part of the regular business of the employer. And in this case, that would be kind of a difficult factor to analyze, because GrubHub essentially is in the business of delivering food, right? So they're not in the business of preparing the food.
But here's the question. Does the delivery person, is that the only thing they're doing? Maybe he's an Uber driver and a Lyft driver and a GrubHub person and a,
But I don't think that matters. Because just to establish a prima facie case that you're an employee, all you have to do is state that there's a relationship where you're performing work and labor for another and getting paid for it. That's all you have to prove. So I don't think it matters if you're doing a whole bunch of other independent contracting.
I think based upon this, I mean, it's got to be a little broader than that. For example, if I'm a contractor and I hire somebody to come in and put up my drywall, they're performing a service, and I'm paying them for it. But they're clearly an independent contractor. And the reason why is they're free to put up drywall in any other house. They bring their own tools.
They set their own hours.
They set their own hours. They set their schedule. Basically, all I'm saying is, I need this installed by this date because I got somebody else that's going to come in and paint it. I'm hiring you to do it. You take care of it however you want.
That's exactly right.
Well, kind of however you want. No, you don't. You got to do it this way.
Competently.
Right.
Right, and there's a contract that lays out the different criteria that you have to meet. You have to build it according to these specifications. You have to use these types of materials. When you do it, there may be a deadline. You have to get it done by the 5th of January.
Right.
But other than that, the way that you do it, the tools that you use, the employees that you bring to the job, all of that is up to you.
So how does GrubHub differ? Are these people completely working for GrubHub most of the time? And is it their car? I think it's their own car, though.
It's their own car. It's their own car. It doesn't take a ton of skill to be a driver. I mean, you just have to have a California driver's license.
There's little skill right there.
So putting this in the case or no case context, this is, and this case is still pending.
Right.
So in July, the court ruled on a summary judgment motion. GrubHub made...
Why don't you explain what that is, Chris?
GrubHub made a motion, and they said, look, we've done some discovery. We've talked to the driver. We've talked to the people who are in management positions at GrubHub about what's expected of the driver. So we've got all of this evidence under oath. We've presented it to the court, and we said, this evidence does not support their claims as a matter of law. So the court should throw this case out before we have to go to a trial. The court looked at the evidence and said that the employer is not entitled to summary judgment. So the driver is able to present his case at trial. And that's basically the ruling that came out in July.
Before a jury.
Yes, but in the context of summary judgment, the court views all of the facts as favorably as they can possibly be viewed for the driver. So just because the driver was able to get past summary judgment doesn't mean that he has established he is an employee, but it's for a jury to decide, or the trier of fact. There may be some judge issues as well to be decided. That will occur at trial whenever that.
And you keep saying he. It's the class action is based under a male's name, a person that's I think it's
Lawson is the name.
Yeah.
Rafe Lawson, I believe that's a male name.
Okay.
Yeah.
So I got to assume that there are a lot of entities that are paying attention to how this lawsuit plays out, like Lyft, Uber, and everybody else, because if this is successful for the plaintiff, that could open the floodgates for suits from other folks that are engaged in similar type business operations.
And it means a lot for the independent contractor or the employee, whatever they're decided, because if they're an independent contractor, they have to pay their own taxes, they have to pay their own estimates, they have a lot of, they have to cover their own liability, they have to do their own Social Security and all of that. If they become an employee, then that's where the employer then is, all of that is shifted onto the employer, and they have to deduct for the state and taxes and for the disability and all of that type of stuff.
So it clear, Denise, that the state and federal, in my opinion, humble opinion, likes it better when they're employees, because each independent little person getting the money, the odds of them completely paying their taxes are lower than finding the employer and making sure the employer is paying the taxes.
Well, that could be, but another way to look at it is, if these people are employees, the cost associated with having them be employees as opposed to independent contractors might make the service unavailable altogether.
That's right.
So don't we want a society where these types of, if you don't want to leave your house to get Chili's buffalo wings delivered to you, by God, in America, you don't have to.
It's true.
So
when we come back from the break, Fred, I have a story back when I did labor and employment law about an independent contractor relationship that was very interesting.
Relationship.
Yes.
Okay, just like case or no case. Well, after the half, we're going to come back, and if you want to talk to us, you can call us at 1-855-LAW-RADIO or tweet us at Radio Law Talk. We'll be right back.
what did we order?
Pizza, I think.
Go to the website, radiolawtalk.com. You can listen to the show there, and there's a lot of other good information, too. That's radiolawtalk.com.
GrubHub Pizza's on its way, by the way. C-Rod, Prince, Harvard. We're still talking about employment law and independent contractor compared to employee. And Todd brought up an interesting little tidbit.
He did. I would much rather talk about independent contractor law in the context of Todd's case.
So this was well over a decade ago. We're talking 15 years ago. I was doing employment and labor law at the time, and we had this client come in who owned a strip club. And he was being sued by
What state? Was this in Nevada?
This was in California.
Oh, okay.
And he was being sued by a former dancer for his club for 3 years of unpaid minimum wage. And the argument was that she was an employee, even though he deemed her as either an independent contractor or, under an alternative theory, as a licensee. Like she was just using the stage that he provided, and then she could keep whatever she made. And so the argument that she made was, I wasn't paid minimum wage. She argued that she was not an independent contractor because he could determine her schedule. He made choices about the type of music that she could dance to, when she had to be there, moves that she could do, what she couldn't do, and was so controlling that he treated her as a de facto employee. Now, his response and the defense he wanted to use was, she made so much money that offset the minimum wage that she claims that she was not paid, because she was making $400, $500, $600 a night for working a 4-hour shift, which is, was good money for what they made. And in research, this is what I found out, and my gosh, I would have never known this. But first, this goes to you, Chris. Can an employer use tips to offset minimum wage? And the answer is no, they cannot. So an employer can't say, well, you made it in tips, because tips are specifically included. And what we found out in
And that's California law.
That's California law. And what we found out in researching this case was about 5 years prior to this case coming in, an exotic dancer's lobbied the legislature in California to modify the definition of gratuity. It stays there. It includes any tip, gratuity, money, all that stuff, but they added this sentence at the end of Labor Code Section 350, Subdivision E, where it says, quote, any amounts paid directly by a patron to a dancer employed by an employer shall be deemed a gratuity. And so all of the money that dancers make that are thrown at them, however they're placed and recovered, are gratuities, and my client could not use that to offset unpaid minimum wage. Ultimately,
Overtime.
or anything that was necessary, and I thought that he would have had plenty of time to, I thought he had a defense, but he decided not to fight it and just settled.
So we have Sean on the line that has a GrubHub question of our panel, especially Chris Rodriguez. Sean, go ahead.
Well, thank you for taking my call. I wanted to know, and I hate to, for y'all to have to repeat this, what is the lawsuit about?
The GrubHub lawsuit?
Yes.
Okay, go ahead, Chris. What's it about?
So the plaintiff in the lawsuit is a driver for GrubHub. He delivers the food when you order it off GrubHub. He claims that he should be treated as an employee of GrubHub under California law and should be entitled to overtime benefits and different items of compensation that he would only be entitled to if he is an employee under California law, as opposed to an independent driver who is contracted to provide driving services to GrubHub.
And Sean, I think, are they, Chris, is this becoming a class action, or is it not a class action?
It is. It appears not to be a class action, actually. Yeah.
Okay.
Yeah.
Which it might be at some time, though. Sean, thanks for the question. We appreciate your call.
Sure, go ahead. An observation. I drive for Uber.
Yep.
And the way I have set it, or the way I'm setting it up, I'm actually setting it up as a business, because the way I look at it as an independent contractor, I would have the same similar rights as a business owner, and would be able to write the tax write-off as well. Am I correct?
Yes, you're right, Sean, and that is one of the reasons why people are independent contractors, because they want it as a business.
Right,
but
they want to be able to write off the expense of their automobile and the mileage that they use, and where they house that automobile and store it, and their phone, because all of these things they have to have as part of their business, and when they have to keep business records and all of these type of expenses. So it does give you write-offs that you would not get if you were deemed to be an employee.
And Sean, I think you brought up a great point, Sean, is it sounds like, oh, this is better for the GrubHub driver to be an employee, but as you bring up, Sean, you're correct. Under the law, sometimes it's better you're an independent contractor, so you can take advantage of the tax savings and tax write-offs.
Absolutely. I mean, that's the way, when I started looking at it, because I've seen, various opinions about, delivery driving, and the way I looked at it was, well, I could be an employee, but I could do better as a business owner, because now I'm able to work for all the platforms and be able to make more money and maybe even work less.
Yeah, that's a really good point, and really good question, too.
Absolutely. Everybody needs to make that decision for themselves, talk to their tax planner, because everybody's situation is different. So, for the plaintiff in the GrubHub case, presumably he's better off as an employee, but in your circumstance, sounds like, you may be better off as an independent contractor.
Yeah, because I have a full-time job. I work in radio, so it's something that I actually enjoy doing. So, well, thank you for taking my call.
Thank you, Sean, for the call. We appreciate it.
Come have a slice with us, Sean.
Yeah, Sean, we just invited you to come and have a slice of pizza we ordered from GrubHub that will be here at 11:20 to 11:30. And the thing is, they're all like, hey, let's get the GrubHub guy in here. We can't do that. We'll get sued probably because we didn't ask him. But we'll let him drop the stuff off, or he or she, and we're gonna enjoy a GrubHub. And I guess it was $3. Is it, Seth? It costs $3 for GrubHub, and then the tip is $3.95. Is that right? 3 and 4. Cal, tell Cal. What is it?
So $3 and $4, is that what we got?
$3.45.
$3.45 and $3.45. Yeah.
So it's and then we're getting the pizza, and it's coming from. Hey, let's do a shout out to California Pizza Kitchen. Hey, we're getting the pizza, and it's going to be here.
I'm going to ask the driver if they want to come on. They're welcome to, but we just kind of have to ask them in advance. We can't just sandbag them and
no, that would be.
Where's the fun in that?
Let's show our listeners what a deposition sounds like. Let's get this guy in here, put a headset on him, and let's go to work.
Well, in California, there's a misdemeanor offense to audio record any person without their consent. So, of course, Cal, being who we are, we're going to have to get his consent.
We're going to depose him without his consent.
Unless it was patently obvious. So if we all have microphones and the guy comes in and is willing to talk, there's a bit of a defense there.
There's 4 lawyers.
It's the surreptitious recording where they get in trouble.
Yeah, it's 4 lawyers staring you down. You want to come in and talk?
Yeah.
Any smart person is going to go, no.
Yeah. Well, Chris is writing down questions like, "Isn't it true?"
Absolutely. I want to get my hooks into this guy.
Well, what I'm worried about that, I think Rodriguez is going to send a bill. He's going to figure out who to send the bill to. I'm not quite sure where he's sending the bill. But
Well, it depends how it goes. I'm either going to send it to Mr. Lawson or to GrubHub, depending on how the deposition goes.
That's exactly right. Hey, so let's move on from GrubHub. Those were great questions. Thank you, Sean, for the call. It will affect, depending upon how this case comes down, it can affect Lyft, Uber, other independent contractor companies, and even Todd's
Exotic dancer.
Exotic dancer.
Ladies and gentlemen, put your hands together for Todd.
Yes. It would be the only time where in a couple we're going, put it on, put it back on. I start out in a pair of shorts, and by the end of my routine, I end up fully clothed in snow gear. Yes, that's the way that it works.
With a fur jacket.
Yes, with a fur jacket, please. And then all the patrons leave going, I will never be able to unsee that.
That's exactly right. Well, so let's start talking about the banks. We were tweeting about banks. What's going on with the banks being sued or not being able to be sued?
Well, during the crash of the banks, more regulation came out, and they were regulating the banks a little closer, and banks often, in their agreements with their customers, have arbitration clauses. And so if something arises out of the banking relationship, there's an arbitration that usually takes place. Recently, there were big banks that were going beyond their agreements with their customers and actually doing things that their customers did not sign on for or consent to. And so under the Obama administration, they tried to do a little more regulation, and it was going to allow for there to be class action suits in this type of a case, and where they weren't going to force people to arbitration, but they're going to allow for there to be class action suits against the big banks.
And the arbitration clauses weren't going to be valid.
Weren't going to be applied because they didn't sign on to that arbitration clause.
Gotcha.
So now in March, that issue arose again, and very quickly things changed.
Okay, we're going to talk more about that when we're back from the break with Denise Dirks, our illustrious co-host, and really the smartest one between all of us.
Hey, feel free to tweet us at Radio Law Talk.
Or tweet. Tweet us or tweet us.
Tweet us or tweet us.
Or call us on Twitter. No, RadioLawTalk.com. Thanks for listening.
Hear past episodes of Radio Law Talk on RadioLawTalk.com. Just click on the podcast tab. Happy listening.
This is RadioLawTalk.com. And now, back to the show. Fred?
Well, I'll tell you, we're having so much fun here. I don't know how we can even talk about the law. We're talking about Denise and class action suits with the bank.
Hold on, Fred. But before we went to break, Denise said you gave her a hard time for saying treat us instead of tweet us. She misspoke. And Todd and I are over here going, is this guy for real? You're going to get on her for that? Earlier you said that you had fun riding the Matterhorn. The Matterhorn.
I didn't say the Matterhorn?
No, you didn't say the Matterhorn.
Oh,
and I mean, it took all of our self-control not to call you to the carpet for that. And there you go, getting on Denise.
Yeah.
Sorry, I apologize.
I mean, you made me crack up when you said blurry lines instead of blurred lines.
Yeah, I just don't. Well, when I have to talk most of the time, I have to say things, and sometimes, guess what? It's age and dementia.
Oh.
And being the king of the malaprop. I mean, that's...
The mala what?
The malapropism is when you misspeak, as you just did. It's the malaprop or malapropism, Fred. I'm sorry.
See, that's my problem. Maybe I should change and not be them anymore.
If anybody has any pictures of the Matterhorn, if they've ever been on the Matterhorn, please tweet them to us, okay? And we'll filter them appropriately. But go ahead and I think there may be one of the attendants for the Matterhorn we just tweeted out.
Why don't we have Seth working for us? What he does is he and Rodriguez are about the same level, 3rd, maybe 4th grade. Remember, like in 6th, 7th grade, when you talk about as boys, I don't know, did the girls do it too? You talked about little silly, stupid things that you shouldn't have talked about.
I just spent a week listening to the silly, stupid things that 6th graders talk about.
We're definitely below that.
Yes, and quite frankly, I think that the 6th graders that were in the cabin that I was chaperoning for my son would all go, "Dude, really? Seriously? Seriously, Chris?"
Would you talk about the law? Let's talk about the law.
I want to talk about the picture of Todd and a man.
No.
Yeah, I told him to take that down.
It's not going to be there. It's not me.
Well, I didn't mind until I saw him holding the cat, and then it was all.
Okay, let's start with Todd's cats. Those of you listeners,
I didn't think that's what he was holding.
What?
Okay, guys, let's turn around here.
Hashtag Matterhorn.
Welcome to the jungle, Denise.
Welcome to the Radio Law Talk. Someone just tuning in going, what is this? A bunch of weird people laughing. Denise, let's talk about the law. Let's continue this boring subject about banks. Or we can talk about the Matterhorn.
Okay, so this law was supposed to take effect. It was supposed to allow
Wait a minute. Cal can't even I don't think he can't push the buttons anymore. He's out there laughing so
I was
hard.
thinking of Rip Torn and somebody coming up and saying, "What's the matter, Horn?"
Is this better than what was the one we did a long time ago about the guy that was passing gas and Cal backed up too far and it was a picture? Wasn't it the guy was talking? Remember he was talking about how he Durst admitted killing someone and then Cal backed up to when he was in the bathroom.
But that's when they got the audio. The version that's out was sanitized, so to speak.
Right.
And you want to hear the worst thing about that?
Go to our
Hang on.
YouTube.
The worst thing about that is our most recognized YouTube.
Oh
spot.
my gosh! Go to YouTube and click on it. I don't know what it's called, but it's the spot where Cal keeps playing over and over the man passing gas in the bathroom, but it's on air live.
Yeah, and we were talking. I mean, the segment was about the Constitution presently of the Supreme Court. How do you not talk about flatulation whenever that's your topic?
Supreme Court.
I mean, of course you have to.
His confession was overheard over him going.
Going to the bathroom. That's I don't know why he doesn't have a million. Hey, Seth, can you figure a way to throw that back up again? Put it on our Twitter page. The old Hearst. Is it Durst? Durst.
Matterhorn.
Jeez.
Yes, Cal, throw it up. A lot of stuff is being thrown up right now. So
Our listeners are throwing up in their mouth.
Denise.
Yes.
Denise.
Please.
Is there something we have going on with the banking industry?
So Denise, can Wells Fargo be sued in the class action
We're not talking
lawsuit?
about any specific bank here.
Or a bank like that.
Just a general
right
bank.
now, in March, foreseeably they could have, but in March the Congress and Senate used a really unique little tool or procedure called the Review Act that allowed for them to repeal that law that was going to allow for there to be class action suits against banks.
Okay.
So now banks they're not subject to class action suits. If you have a dispute against your bank, you're going to have to do either arbitration or file individually if there's not an arbitration clause involved. And this it goes both ways. Part of the people are saying, look, we're not protecting consumers. This is not fair to consumers to have to take it on individually.
Because the bank's got the money.
Bank,
Yeah,
right? But the other side of the coin is if the banks have to take on these big class action suits, there may be 3,000 or 4,000 or 5,000 class action suits that may hurt the bank.
Well, here's what people don't understand, and us as lawyers understand this. A lot of it's going to be passed through, by the way. You think, the bank's going to hit? They're passing it through to the consumer, so it's us. But go ahead, Chris. Chris does a lot of this type of law, and he's seen the side where consumers have actually taken advantage of it to a nth degree.
There's no question. There's There's no question. And many lawsuits that come against banks, the banks would like them to be in arbitration because they want somebody who is impartial, that can analyze the facts and the law and make a decision. And a very high percentage of the time, the arbitrators that are very smart and very dispassionate, they're not biased one way or the other, they come out in favor of the banks. A lot of the plaintiffs would like their case to be in front of a jury because juries, as a practical matter, don't tend to favor large corporations like banks.
Right,
and so that's kind of the underlying
But there's
thing.
also an argument that the arbitrators benefit by these contracts that are held by these big businesses, and that they may subconsciously be pro-big business as well. They're not supposed to be. I mean, they're trained to not do that, and they're trained to actually look at their bias and overcome their bias, so they're not biased against either party.
Isn't the bottom line that people who sue have a tendency to be emotional, and the arbitrator says no emotion in the case, here are the facts, black and white, that's how it's going to be. So the guy says, I got ripped off, even though the points of the law may actually favor the institution and the arbitrator.
Wait a minute. I'm going to argue. I'm going to jump on the other side.
I'm just asking.
Yeah, no, I agree with you to some degree, but guess what? It's the lawyers that are passionate, too. You talk about the plaintiffs or the defendants passionate. A good lawyer can look passionate and do the same thing on either side. So it's lawyering. It's good lawyering too. It's a show, Cal. It's a show.
Good
Yeah.
point.
And it's really it's theatrical. It really is. People don't realize being in court is theater. Now you do have to know that have the bones, but there needs to be theater.
I just want to say that there was another act from last year, another law that was coming in. It was called the Consumer Bureau Rule for the retirement advisors, and I was impacted by this. That's where your retirement advisors now have fiduciary duties. And in fact, the Republicans Congress tried to overturn it by the same way, and Obama vetoed it. So there's still that law in effect, and it's in effect now.
Huh. Interesting.
You know, you were talking about good lawyering is theater. Do you remember Jerry Spence? Does that name sound familiar?
Of course you do.
So
From Wyoming.
So Jerry
in fact, one of our lawyers took one of his classes.
And he has the Jerry Spence Trial Academy, and one of their instructors came to my law school way back in the 90s when I was in school, and he has a theater background. That's all he does. And he came to our trial practice class, and his whole presentation was on teaching the lawyers how to avoid having your body language torpedo your case. You could work 6 months, a year on a case, multi-million dollar, and you lose it because you stand in front of the jury with your arms folded and your head down, and you pace in front of the jury with aimlessly, and they hate your body language, and you torpedo your case. And that really spoke to me about being an effective trial advocate is like being in theater, and everything you do has to be with a purpose. You almost want to block out how you're going to move in front of the jury because they're paying attention to everything. You get focused on the facts, they're looking at everything.
Including what your client is or is not doing. And that's what a good lawyer understands. A lot of these lawyers, I went up against a lawyer one time in trial. He was so intellectually smart. The guy was brilliant, but clearly he was not touching the jury. And I knew when I rolled in, this is going to roll for me. Just because he was so smart and intellectually, but the jury, you could tell they were just sleeping. Look at a jury. The best part is, as a lawyer, you always watch that jury. If you see him kind of nodding off when one of your witnesses are testifying, okay, move on or figure out what's going on. So
you just made the case for why businesses want to be in arbitration.
That's exactly right.
Because the arbitrator doesn't care about your body language.
That's exactly right. So this is coming to the end of the second hour.
Hey, thank you to Tiana Ju from Whittier School of Law, who did our research today on GrubHub.
To Radio Law Talk.
Yeah, and join us. Back in about 30 seconds, we're going to leave here, but join us the third hour when we're going to talk about Bill O'Reilly, Kevin Spacey, and the Flint River.
Is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
I'm still waiting. November 4th, 2017 is today, but November 3rd, 2017 was an epic day. It was Love Your Lawyer Day, and I still have not received any cards from the listeners.
That's not true. You received one card today.
From the listeners.
Okay. I said from the listeners.
Qualified it at the last moment.
That's exactly right. I'm Frederick Penny, Radio Law Talk, and with Denise Dirks to my right, we got Todd Cunin and Chris Rodriguez. Behind the glass is the 3-time Emmy nominee, Cal Hunter, our producer.
Keep reminding me of my failures. Thank you.
And Seth Madden, our call screeners. We are excited to be in our third hour. Those of you who are joining us from K-High, welcome. If you didn't hear the first 2 hours, it'll be played the next 2 hours on K-High, or you can listen to us on our podcast at www.radiolawtalk.com.
Can I ask Cal about the Emmy nomination process? Did you get to go to the Emmys?
Yes, I went to this is actually, there are regional Emmys, NAT, Northern California Arts of Television Arts and Sciences, NATAS sort of. So every time they'd have a dinner, we'd be nominated, and then we'd go down to San Francisco and have a dinner, and I'd watch other people win, and I'd go home going, I'm just too fragile for this.
Did you get a good dinner?
Oh, yeah. Sure.
Go down there. What the heck?
I got to hang out with some really good TV people, made a lot of good friends. I don't know if any of you remember George Watson, used to work at KTVU in San Francisco, really good guy. A lot of good just got to meet a lot of good people and lose.
I know what's interesting about all that great stuff that you did and those people you rubbed your shoulders with, and now toward the end of your career, or I hope you got a long career, you're stuck with Radio Law Talk.
It's a valid point, Fred.
You've really gone down to the depths of the bottom.
Here I was, a television news anchor in a small market at the peak of my mediocre career.
Stuck with Radio Law Talk.
Cal, I got a question for you. You know how you mentioned always a bridesmaid, never a bride?
Yes, of course.
When it comes to Emmys. Now, at weddings, you have the bride will turn around and throw the bouquet to the bridesmaids and everybody else. How do they do that with the Emmys? Do all the people that didn't win all gather around, and then the person that won the Emmy turns around backwards and throws like a pickle or something back to them? How does that work?
How it works is they hold the Emmy up and they rub it in your face, and then they go home.
Okay, you know what our job is, guys? To make his life full, we're going to have to win an Emmy. Radio Law Talk has to win an Emmy.
I'm for that, or a Marconi, a radio award.
Oh, is Marconi? Okay, well, whatever that is.
My Emmys were for television news work.
Okay, so Marconis. You know what? We want to do. Okay. We've got our illustrious Seth Madden. Seth, find a Marconi Award picture and let's tweet it out. Our goal is to get a Marconi Award for Radio Law Talk, especially the producer, so he can feel better about his life.
I feel fine about my life. Like I said, it's been a very fulfilling, wonderful career so far, and I'm just starting a brand new one with you guys.
That's exactly right.
And it is very impressive. I mean, all joking aside, we joke about it all the time, but to be an Emmy nominee
is phenomenal.
For being on TV is great.
It was kind of cool.
Seth, when you're looking for that picture, stay away from my yearbook, will you please? All right. So.
Hey, if you want to call in, call 1-855-LAW-RADIO or tweet us at Radio Law Talk. And that 1-855-LAW-RADIO, Denise, what are the actual numbers?
It's 855-529-7234. We're also on SRN Satellite, and we are also available at the YouTube channel.
That's exactly right. And we'd like to thank our mother station, which is Crack and KBLF up in Red Bluff and Redding. Thank you very much. And those of you who are first joining us from K-High, thank you for being here. Like I stated, November 11th, we're excited. The Nevada Talk Network is rolling in, and that's about 5 stations they're gonna start airing our wonderful show. And we've had fun the first 2 hours. The third hour, we're going to talk about the Flint River water contamination, Bill O'Reilly, but more importantly, we're going to talk, and then we're going to have a case or no case we're going to talk about, when we'll describe what a case or no case is. But Chris, you're going to talk about Zeke Elliott, the update. And
Sure. For all you fantasy football players out there, you may have heard the Second Circuit Court of Appeal has now weighed in, on the Ezekiel Elliott case. As of last week...
Well, back up. Tell them briefly, what is the Ezekiel Elliott case?
Okay,
Quickly.
Ezekiel Elliott, running back Dallas Cowboys, was accused publicly of having committed a domestic violence act against his, at that time, girlfriend. The law authorities in Ohio, where the alleged incident took place, didn't think there was enough evidence to convict him. He was never charged. The NFL, however, did its own investigation, suspended him 6 games. Ezekiel Elliott alleged that the process by which he was suspended 6 games was unfair. He filed a lawsuit. He asked for an injunction. It was granted. He's been through now several layers of the court process in both the 5th District, which is the district that covers Texas, and also now the 2nd District, which is out of New York. And so the 2nd District has weighed in. They are now, as of 2 days ago, allowing him to play this week while a 3-judge panel of the 2nd Circuit considers whether or not a longer stay should be in place to allow him to continue playing. So for now the 9th week in a row, he has avoided the suspension. If you have him on your fantasy football team, as I do, go ahead and put him in your lineup.
I just wonder if any of the judges who have ruled to basically stay the imposition of the suspension play fantasy football and have him on their fantasy football team.
That's a good question.
You know, that would be interesting to find out if the judges, well, you know, I could impose the suspension, but he's on my team, and I really want to play him this week, so I'm going to kick the can down the road to somebody else and see if I can get some points for Zeke Elliott.
When Chris was talking, go ahead.
And what's interesting, he lost in arbitration. He takes it to state court, right? He gets a stay at state court. That gets appealed. He loses that appeal. Then he goes to another place and gets another reinstatement of the stay.
Exactly.
It's like, wow.
No, this was the first thing I thought. Who's on first? You know, you heard that old saying, who's on first? I don't know who's on second. I'm a lawyer, and that's confusing.
Yeah, it is confusing. It doesn't make the legal system look very good. In fact, at the last hearing, his lawyer got up in front of the court and said, and that's what carried the day.
That's exactly right.
It's like farm shopping.
Oh my gosh. All right, let's talk about case or no case. And before we get there, we want to thank one of our research assistants. We have this special plan that we throw out there for law schools that have 2nd and 3rd year law students will do the research for us. Now again, we don't, this is nothing personal against them. We use that as a base, and we still do our own research and double checks things, but they do a great job for us, and it helps us out. And who's the person we have to thank today?
We want to thank Tianu Ju from Whittier Law School. She's done a great job today, and we really do appreciate the time and effort she's put in to assist us.
That's exactly right. So what we have now is...
She's going to get a mug autographed from us, and we will always say thanks.
And she gets a $100 scholarship. That's exactly right.
And when she passes the bar, the time she spent doing the research will be worth probably about 15 times that. 15
times, that's about right. Is that what your firm pays? I'm coming to work for you. Well, we've got 1 minute, Cal, so I was going to go to case or no case, but let me tell you what case or no case is before we go to the break. Case or no case is a special thing that we do that's a blast, and we want you to tweet in or call or email at info@radiolawtalk and be the judge also. So what's going to happen is Cal's going to give us a case. We're going to talk about the case. We're going to decide, number 1, whether or not it's a case. Number 2, whether or not who's going to win or not win, and what the damages are. And here's the key. And we raised our right hand to the square the first hour. He put us under oath that we say that we do not know what he's going to say.
Yep. I just say yabba gabba if you agree. Yabba gabba. Okay. So this next case I'll bring to
we have 30 seconds.
I'll bring it after the break.
Sure.
It has to do, well, I'm just going to say it's a wee little case. That's all I'm going to tell you about. That's your hint. That's your tease.
Okay.
Our case or no case is a wee little case.
Okay.
So on a related note, go to our Twitter page and check out Todd's high school photo.
Hey, listen up and stay with us.
It's also a wee little case.
past episodes of Radio Law Talk on radiolawtalk.com. Just click on the podcast tab. Happy listening.
So before we get to our case or no case, we had our GrubHub guys show up and deliver our pizza. The first hour we talked about GrubHub and whether or not either independent contractors or employees, and how maybe that affects Uber. So go back to our first hour.
Was it the first hour?
First hour or was it second hour?
Time flies. I really don't remember.
I don't remember. Was it the first hour or second hour? Second hour. Okay, go back to our second hour and listen to it, the podcast. And we actually called the GrubHub person to deliver, and they delivered the pizza. We're going to have a picture up of the GrubHub pizza person, and he actually gave us permission, so it's okay. And
In German.
And guess what? Oh my gosh, I could smell the pizza, and it's killing me.
Yeah.
And we're sitting here trying to do case or no case. Go with case or no case, and I'm going to start eating. Go ahead.
Is this diet approved, Fred?
No, Fred's going to go ahead and just take a little small piece of pizza here. And once again, you've already sworn that I have not informed you about case or no case, so let's get right on it, shall we?
Case or no case?
Hey, you guys talk. I'm going to have a piece of pizza.
Pepperoni or no pepperoni?
Pepperoni, are you hungry? Yeah.
Okay, here we go. I take you now to the great, probably the best weather in California, to San Diego, California.
Yes.
Beautiful Jack Murphy Stadium, the stadium they call the Jack or the Murph. Most people now call it the Murph or the Unoccupied, since the San Diego Chargers have moved. A gentleman there attended a concert featuring two classic rockers, Billy Joel and Elton John. Good for them. I missed the concert. I wish I didn't. He goes to a bathroom, and in the bathroom, he sees a woman using the urinal facilities. He realizes to his horror that Jack Murphy Stadium has a unisex bathroom policy. He tries several other bathrooms. Same thing, all women in the bathroom. He says he's so embarrassed that he had to use his words, hold it for 4 or 5 hours, and figured that it was worth about $1 million an hour in his lawsuit against the city of San Diego and the people who operate the Murph. And so, the first question, ladies and gentlemen, I ask you is case or no case? All right, go ahead. Brad's going to grab another piece of pizza. Okay, case or no case? Let's start with you, Todd Cunin. Is it a case?
Okay, so I have to ask a couple of factual questions. Are you positive that this is Jack Murphy Stadium?
Yes, I am.
Jack Murphy Stadium. Okay. And it was a unisex bathroom.
Bathroom policy.
Bathroom policy.
It may have been a policy adopted just for that concert. I'm not certain.
Okay. I am going to talk about a technicality here, which is this. Jack Murphy Stadium switched over to Qualcomm Stadium way back in the 90s.
Well, this was 1995. I'm just pulling a year up, but let's say before that, then 1995, okay?
Okay, but the reason why I'm talking about this is the unisex bathroom stuff did not really start and become an issue until the last 2 or 3 years, which would have been well after Jack Murphy Stadium changed its name to Qualcomm Stadium. So if that happened in the 90s, when they changed the name, and if it's positive that it's Jack Murphy Stadium, I would say based upon the technicality there, because I think this is a made-up case.
Okay, so you're saying wrong.
I'm saying it's a made-up case.
Chris Rodriguez.
I'm going to say that this is a true case because, and here's my reasoning. I can see, even if this concert took place in the 90s, Billy Joel, very liberal New York fella. Elton John, classic human rights, gay rights advocate. I would say that these people are so woke, as they say nowadays, that they forced the concert promoters to have a unisex bathroom policy for them to show up.
So you say it is, in fact, a case.
I believe that it is a real case because of these gentlemen that were performing, pushed for that. And I believe that this man has no chance whatsoever of getting damages for having to hold it for 4 hours.
Okay. Fred Penny, how's the pizza?
My answer is, I don't care. I'm eating pizza. Move on. I'm done. Go ahead, Denise.
So case or no case, Fred?
I don't care.
He needs a case of soda.
I'm so happy eating pizza right now.
It doesn't work if you say you don't.
Case.
Okay.
Yeah, case. I'm so excited to have my pizza. I can't function on the radio.
All right, Denise Dirks, is it a case or no case? I can tell how this is going to go.
There's no pizza left, by the way, if that matters.
Yeah,
Fred ate the whole darn thing.
Tell him why. Tell him why I'm enjoying this pizza.
Fred has been on a very aggressive weight loss program. He looks terrific. But I can tell how it's going to go when he says my diet is over.
My wife doesn't know. Denise is the only one that's in charge of watching me, and she is allowing me to have a piece of pizza.
Allowing? You almost plowed me over.
Oh, my gosh.
I tried to tackle you on your way to the pizza box.
I do not want to talk.
I think when you're back up to 475 pounds, you're going to have a case against GrubHub.
I think any employee of Fred's law firm now knows that in order to get a raise, they submit a written request with a piece of pizza stapled to the request.
You got it.
So, Denise,
Feeling good.
was this man right to? Did he have a case in suing for having to hold it? Is that a case, first off, or not a case?
I got a whole.
I have to say, not a case.
Okay, so you're saying I'm wrong, it's not a case.
I'm saying that
Based on?
it is not a case. Well, because you used Jack Murph, and maybe that was a mistake on your part, and you should have. Because if it was recent, not in '95, but recent, I probably would have gone more for it's a case. It had to be after Ally McBeal days, right, when the unisex toilet in that show was very popular, and so I'm saying. No case.
You're saying based on the year and the stadium identifier,
Yes.
it's not a case.
Correct.
All right, Fred?
No, go ahead. I said we got 1 minute. Tell us.
Well, I'm not going to tell you.
You're not going to tell. Okay, hey, Denise, will you pass a napkin for me?
Don't pass Fred on
I want a napkin. I am so happy right now.
Some napkins
What
for
we're going to do when we come back, we're going to talk about a little bit about the Bill O'Reilly case, and it's going to talk about defamation, libel, and slander. We're going to talk about the difference between the two.
Fred is dabbing the napkin.
Would you
in
be
pizza
quiet?
face and eating the napkin.
Oh my gosh, I'm so happy.
Remember,
right now.
we're talking about the generalities of law. If you need
Yes.
to talk to a lawyer, get a local attorney.
Barely. We're barely talking about the law.
I'm happy right now.
The
Let's
answer
move
to
on.
case or no case is coming up, I promise. Stick around. All right, now it's time to go back to RadioLawTalk.com. Let's go to the studio where we can find Todd, Chris, Denise, and Fred. Go ahead, please. Todd, Denise, Chris.
Pizza.
That's it. We're changing the rules. No more food for
Oh, yes. Food goes in here.
Very nice, you guys. That's good.
I'm still eating.
Yeah, and the pizzas. I noticed the pizza's all gone, but you guys. Denise, how was it? Let's give it just a
Actually,
rate.
the pizza was pretty good.
Yeah, good.
Yeah, especially pepperoni pizza at, 11 in the morning?
How bad can it be? I know Fred's enjoying the heck out of it. Fred, put the box down. Don't eat the box, Fred.
I'm not ready to eat the box. You give me cardboard now, and I eat it.
Todd, your thoughts on just a review for the pizza, in all fairness.
Well, he can't talk right now.
Thanks, Todd.
Really good. I liked it.
And Chris, obviously you enjoyed yourself there.
I did. I
Yeah,
did.
good.
Had nothing to do with the pizza, though. No, hey, let's change the subject.
I'm really curious
moving
about
my
this
chair
case or no
over.
case.
Case or no case? You got
Okay, now here we go. Once again, the parameters to the case. 1995, Jack Murphy Stadium. Man from San Diego goes to a Billy Joel, Elton John concert, tries to use the bathroom, sees women in the bathroom, one of whom was actually using a urinal in a way that made him very uncomfortable. He said he went around to all of the other bathrooms in the immediate vicinity, couldn't find one in which there were not women. This made him so uncomfortable, he had to hold it for 4 or 5 hours. He was too embarrassed and humiliated by the whole situation, and so did he or did he not sue the city of San Diego and Jack Murphy Stadium for his right to take a wee? Denise, case or no? Just remind us of your answer. Case or no
Well,
case?
I said no case, but now you added a fact. You said a woman was standing up using the urinal.
Not standing, just sitting on the urinal, because there was
okay.
no. Yeah.
Okay.
he was
No
standing.
case.
It just made him uncomfortable. Fred, case or no case?
no case.
Okay. Case or no case?
I'm going to say the Uptown Girl did not exist. No case.
Chris Rodriguez?
And I'm going to say, based on the notorious liberalism of the two artists who were performing that night, absolutely a case.
Those of you who said no case...
Oh, Sue-Rod wins.
No, it is no case.
The case was filed.
Oh, okay. See, there we go. Sue-Rod wins.
Chris
There we go.
Rodriguez wins in the fact that there was no case. However, by the time it got reviewed by a panel and presented to a judge, the judge looked at it and said, I'm sorry, I wish I could help you. But so there was no money or an award, but he did actually file a case, got a lawyer to take the case.
Wow.
It was 1995. It was Jack Murphy Stadium. The gentleman's name was Robert Glaser. And he said his emotional distress and embarrassment from the sight of women using a urinal in front of him and then causing him to go to other bathrooms was such that he was scarred for life.
They were using the restrooms like a candle in the wind.
You could say that.
Sorry, I'm just referencing Elton John and Billy Joel songs. Uptown Girl, Candle in the Wind. Nobody gets this?
I get it.
Okay, all right. So the Rocket Man lost his case.
We got it, but we weren't laughing.
Okay, isn't the first line of Rocket Man?
Yeah.
So I think it's gonna be a long, long time.
Actually, the first line is she packed my bags tonight pre-flight.
Okay. But the guy had to wait a long, long time.
That's the point.
Yes.
Can we talk about the law?
Well,
Yes. Why would we do that? I mean, it's not like it's in the name of our show.
Bill O'Reilly is suing for someone for defamation, and so there's libel and slander and defamation. So there's two things. Libel. Let's just go over some quick general rules and law for the listeners, and let's talk about this. First of all, libel is a written statement or it's a published statement. Slander is spoken or said. And so Bill O'Reilly, a former Fox News host, has filed a defamation suit against a Michael J. Panter on October 24, 2017 in New York, seeking $5 million in damages. Now, this Panter is a former New Jersey politician he's claiming his ex-girlfriend was sexually harassed by O'Reilly and went on his Facebook page and wrote a bunch of, quote, according to O'Reilly, defamatory stuff. And again, these are allegations going both ways. So we're not saying who's right or who's wrong.
Well, he put it on his own Facebook page, not O'Reilly's.
So there's a couple of important things you have to remember. First of all, here's some quick examples of defamatory statements. When it's involving, you claim that they involved or committed a crime of moral turpitude, or that's
like per se violation.
Yeah, right.
Unless you have truth as a defense.
That's exactly right. And we're getting. I'm just throwing some examples. Anything that's going to reflect the negativity or morality, integrity of a person, impairs their financial well-being, and now with social media, this really makes it so it's more. It's easier for people to be sued for defamation.
Well, we defamed Todd probably 14 times during the last segment of our show, including by posting what purported to be a photo of him from his high school yearbook wearing a leopard skin mankini.
You know.
Well, I think that actually defamed the person depicted in the picture.
No, it defamed our radio law show. That's the problem. We're fired.
We're moving away from law again.
So this is the thing. I would fire Seth Madden, but no one else would come and do his job for nothing, which is what he's getting paid. So we can't get rid of him because he would leave. He would gladly leave. But go ahead, Denise. Let's talk about this case.
Okay, so the defamation case with Bill O'Reilly. First of all, Bill O'Reilly is a public figure. So in order for him to prevail, he has to show that this was a false statement that was made with actual malice, or the defendant knew that it was not true, and that he did publish it to a third party without any privilege or authorization, and that it has caused harm to Bill O'Reilly's reputation, financial circumstances, et cetera, et cetera.
Do we know
So let's
in
talk about
particular what he said?
Yeah, let's talk
Yes.
about the case. So she just laid it out so you understand what's going on.
Right. So he
what's
said,
it
this Mr. Panter said that his former girlfriend, he was present when Bill O'Reilly would call her late at night and make suggestions, and that
Did he ever ask her to ride the Manor horn?
Could you press the button, please? Is it too late to press the button?
He said the manor horn, which is okay.
Okay, keep going.
Let's put it this way. She says that when he called her, she believed he was riding his own manor horn, and that
that came from Denise.
What?
And that it was sexual harassment, basically. And this happened over a series of different calls, different actions, and it's still apparently posted on the Facebook account of Mr. Panter.
He changed it just a little bit and said it's true, though.
He did say it's true.
This is true. That's why I put it.
This is true. This happened, and apparently his the former girlfriend's going to back him up on it.
And I guess also, Denise, that he's claimed, this is an accusation, that Bill O'Reilly called her and said, hey, there's someone else going to sue me for sexual harassment. Do you have any goods on this person?
That's right.
Yeah.
That's exactly right. And so she felt kind of trapped, I think, in that whole circumstance, that she had to either give him goods. Oh, I'm sorry. Had to get. How do I get out of that one? That she had to.
Was a waiver signed? That's all I want to know.
Don't know.
Cause a case or no case from the first hour. Remember that?
Yeah. So my understanding is she didn't give up any goods against another woman.
Right.
That she didn't back him in his endeavors to try to slam or deface or defame or other people.
Again, now this is all coming from the side of the defendant that's being sued by O'Reilly, and this is what they're trying to claim. So again, this is allegations. I always say it twice. I've said it. Allegations. And don't forget, at Radio Law Talk, we're talking general areas of law. Go get a lawyer if you have any questions in detail. Go ahead.
Right, and it really does impose First Amendment concerns, the right to speech. When are you limited in your right to speech? And it also impacts the Fourth Amendment, I believe, too. The 14th, excuse me, as it applies to the states, right? And then, help me out, guys.
Well, here's the thing that's interesting about this. Let me talk about this. Where I kind of just, said wow about this case, because to me that's just a typical defamation case that I hear about all the time, is what are the issues when it comes to social media sites? Can you sue the social media sites that are allowing this to be posted? And there is the Communications Decency Act of 1995 that was passed, where it protects websites, ISPs, from being sued for defamation. And I knew it was difficult to win those cases, but I didn't know there was the actual act after I did my research and found that. So the act of, Facebook printing it, good luck in going after Facebook, because if that's the case, what's going to happen to all of our social media sites?
Yeah. Right. Well, that was a change in the law that was warranted because of the social media aspect, because the law is subject to this exception. If you publish somebody else's statement that was defamatory, you are also potentially liable for defamation. So that's why that law was needed.
Right.
And so we have also, Facebook is a general purpose site where people can post all sorts of things. The flip side, and we don't have a whole lot of time here, but a website, say hot or not hot, where the purpose of the website is for people to go on and post photos of other individuals to then make derogatory statements, a site like that might have a more difficult time defending in a lawsuit, because the purpose of the site is to garner these bad comments. But we can talk more about that when we come back from the break.
Hey,
we'll be right
tweet us at Radio Law Talk.
Go to the website, radiolawtalk.com. You can listen to the show there, and there's a lot of other good information, too. That's radiolawtalk.com.
We're still talking about the Bill O'Reilly defamation lawsuit. Remember, we wanted to talk about the Flint River water contamination case and the Legionnaires and Legionella. That is a lot of the things that people are getting sick from the water. And that is a really interesting area of the law that we've actually handled some cases, and I've actually been interviewed on the radio before a number of years ago on the Legionella case. In fact, one of our cases from our law firm was actually put on NBC Nightly News, and my partner Kevin Elder was interviewed. But we're not going to have time for that because we want to talk more about this Bill O'Reilly. So next Saturday between 9 and noon, of course, it's Radio Law Talk. We will talk about the Flint River water contamination case. But let's jump back into Bill O'Reilly, Denise, about now talking about a public official or public figure and whether or not you're a private figure and how that how that changes. Now, if you want to call in, call 1-855-LAW-RADIO or tweet us at Radio Law Talk.
Right. I personally feel that Bill Riley is going to be held to the standard that he is a public figure. But there's different types of ways to get public figure status. There's a general purpose public figure if he achieves such pervasive fame or notoriety that he becomes a public figure for all purposes and in all contexts. Now, Bill
That's
Riley...
the Getz case.
Yes, and Bill O'Reilly was a host of Fox News for many, many years, and had some controversy around him. And also, he was fired from Fox News recently. But I think he might. I mean, for as long as he's been on the air, he probably is a pervasive public figure.
And stop right there. So I want to interrupt you on that. And the reason I interrupt you because Todd has a different opinion. He was kind of saying he thinks he might not be a public figure.
Well, in the sense that since he has left Fox News or been fired from Fox News, let go, the question would be, is he still a public figure? And over the break, I've been looking at this, and that is actually still a contested area, researching, or the Supreme Court has heard the Getz case, and some have gone up, but they settled before the Supreme Court could actually issue a ruling. But it wasn't clear whether the court would say that somebody could lose their public figure status. My guess is that maybe somebody could make it. I don't know that 2 years or a year and a half removed from being the top dog at Fox would be enough time for Bill O'Reilly to have lost. I think it's an interesting discussion to see if that could ever take place, but I doubt, even if it could, that it would apply to O'Reilly under these circumstances, because it's still too new. And I think he's involved with Newsmax or trying to be involved somewhere else, so he's trying to stay in the public eye anyway.
Yeah, well, the other way he could become a public figure or be a public figure is through limited purpose. And that's where he voluntarily interjects himself he's drawn into a public controversy, and thereby he's a public figure for a limited range of issues. And right now, the context of sexual harassment is everywhere. This is definitely a public controversy that's occurring. And it just seems to me like even if he's not for one purpose, this purpose, he is.
The only alternative I would say to that is this. He interjected himself into the public controversy for sexual harassment as a plaintiff in a lawsuit suing somebody who has slandered him. And if the idea was that by filing a lawsuit, you could then interject yourself, whether it's a hot topic or not reference to the store, a hot issue or not, if you're interjecting yourself by virtue of the fact that you filed a lawsuit as a plaintiff to defend yourself, well, then everybody would be deemed a public figure.
Yes, except for he just settled for $35 million with another plaintiff or another woman for a type of conduct, and he responded to that. And he admitted
so
that
he paid the $35 million.
Yes, he did.
But still, I would argue that
when you respond to a question and that's newsworthy,
I would argue that defending yourself in a lawsuit, if you're sued, defending yourself isn't something that puts you as a public figure, because otherwise every person that was ever involved in a lawsuit, whether they were a plaintiff or a defendant, would be deemed a public figure.
No, I'm trying to distinguish with defending yourself in the public media, not filing a lawsuit.
Well, he settled the lawsuit.
He settled the lawsuit, but he came back and he responded to that, which had to do with sexual harassment as well. And now he's filed a suit for defamation, related to sexual harassment.
Hey, pass me a piece of pizza.
I only have a crust
left. We'll wake a cow up. Go ahead.
I think that when you talk about all these Harvey Weinstein things that's in the news, that's like the hot topic. Again, using that phrase, sorry, Todd, in the news right now. And the next thing that you think of is these powerful media people that are tyrants against women. You think about Harvey Weinstein, you think about Bill O'Reilly. He's in that select group, and there's no question that he is a public figure when it comes to these issues. I mean, you couldn't get any more public, in my opinion.
Yeah, I totally agree. So, I mean, no doubt he has the burden of proof to overcome that the defendant acted with malice. I think he's going to have a really hard time to overcome, even if it was he has a heavy and insurmountable burden, is what people are saying out there, to show the actual malice. But I think he's going to have a hard time even showing that the person that made the statements had no reason to believe what he was saying and that he was dishonest.
Here's something you got to understand about defamation, though. Those of you out there in radio land listening, everyone thinks, well, what I'm going to do is I'm just going to say it's my opinion. But what's interesting, the courts have held, and again, it's all fact-based. The courts have held, though, if you claim this is your opinion, yet your opinion comes across and, quote, acts as a statement of fact, is what the courts say. For example, it's my opinion, X, Y, and Z. And X, Y, and Z is completely wrong about Chris Rodriguez. Just because you said the word opinion, it's still acting as a statement of fact. So be careful out there. Some people automatically think, "Well, I said it was my opinion." Well, it doesn't necessarily mean you're gonna be safe.
My opinion. Let's say it's my opinion that Todd is an extremely attractive male, especially in the photo that's online.
Well, you lose all credibility with that.
Well, okay, but let's just say I have that kind of taste. He is looking for a date. Let's say I have that kind of taste. That is absolutely a classic statement of opinion. But
that's a fact. That's a false statement.
Okay,
that's a lie.
I'll give you an example. How about this? In your opinion, this is one. It's the trick question that they teach us in law school. Let's say it's my opinion that Bob Smith is still beating his wife. Okay, now that would be a problem because inherent in, even though I use the word opinion, what am I insinuating? That it's either still happening or at one time it used to happen.
By the way, Bob Smith's out there saying that you beat your wife.
And I'm stating that as a fact, and I can't avoid liability because I say my opinion, because inherent in the statement is the allegation that at some point in time he was doing this.
Right, exactly. So
now
that would be
problem.
Clearly a statement of fact, even though you've tried to disguise it as an opinion. But a closer call would be, I've gone to dinner a bunch of times with Fred. He's a lousy tipper, right? So that could be a defamatory statement that people now lose respect for Fred because they think he gives bad tips. Right. There's a factual piece of that, but there's also an opinion piece of it. Is it lousy to tip 10%? Is it lousy to tip 20%?
Well, the reason that happens, Chris, is because you're supposed to pay the bill and you never do, and so I end up paying the bill and the tip, and I'm waiting for you to pay the tip.
Well, usually what happens is I pay the bill, and then you ask for like 4 doggy bags to go.
And then not only that, then you bill me by the hour for it. Oh my gosh!
And then Fred orders pizza.
That's exactly. I've had my pizza. So I think this is really interesting to know that in defamation cases, libel or slander, there's a couple of things. Number one, be careful now that you're on social media. This is the crux of what we're getting at. Social media makes you an easier target for being sued for defamation. I mean, so be careful.
Makes you an easier target for all sorts of things, doesn't it,
That's
Seth?
Exactly right. And then not only that, remember, just because you say the word, it's my opinion, doesn't mean anything. So when you're out there listening to this, we're not dispensing legal advice. We're talking generalities. That's very important to know. Denise, tell us about who we're going to thank before we end our illustrious third hour.
We're going to thank our law student research assistant today, Tianyu Ju from Whittier Law School, and Whittier's in South California, and we're thankful for her time and effort.
And you know, I like to thank Cal, I thank Seth, and all my hosts here. We had a great time these 3 hours. Listen to the next 2 hours on our podcast. I'm Frederick Penny. We're the Radio Law Talk. We had a good time. Don't forget, send us a card because it's Love Your Lawyer Week.
And don't forget, if you're going to the Billy Joel concert, use the restroom before you get into the stadium.
Good call. Thanks for listening, everybody.
You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated.